All right, so we can begin for the webinar today, September 20th, 2025. My name is Max Chaudhary, that's Chaudhary, and I'm one of the lawyers here at Chaudhary Law Office. And I have these webinars periodically for the purpose of providing some context to people who have immigration questions and want to get at least a general direction as to how to maybe proceed. This would be distinct as opposed to, for example, legal advice, where we're able to ascertain your factual circumstances with sufficient precision in order for us to give you substantive legal advice. So it's important to keep this in mind, as general guidance and not advice is a distinct concept, because advice requires something more of a deep dive into your individual legal circumstances related to your, for example, interactions with the Immigration Department or the Canada Border Service Agency, etc., when interacting with these types of entities. So with that in mind, I have people who have come and will come and join based on whatever their time schedule is. And as such, I have a list of questions to go through from people who have emailed us and people who will participate by leaving their questions here in the chat. So keep in mind that portions of this webinar will be posted online. So if you don't want your image or voice to be posted online, you may want to simply post your questions in the chat, as I've indicated. So, in other words, keep your camera off and muted for that purpose. That way you can maintain your confidentiality for this. So people can pose questions, and I'll reiterate that by saying in the chat, please post the questions. And if there are follow-ups, you may have to pose another follow-up question, maybe to provide context to the initial question. So in terms of the questions ahead of time, I will try to deal with those. And I look forward to seeing any further questions in the chat. So the first question I see here is, somebody is on a closed work permit. So they're inside of Canada and they've graduated high school in the Philippines, which they've determined is equivalent to grade 11 in Canada. So is it possible for this person to apply for permanent residency? Basically, that's their question. So in this case, there is somewhat of a dearth of facts because we know the person is on a closed work permit. A closed work permit implies that they are restricted to one employer. In fact, it's mandatory that they would be tied to one employer based on the nature of that work permit. And for that kind of situation, transitioning to permanent residency is something which is subject to numerous factors and hence would be in flux. There are lower skilled pathways for permanent residency. These are becoming fewer and fewer because of the general immigration environment in Canada, where there is a concern that there are too many temporary residents in Canada. And as such, a lot of the closed work permits, which led to permanent residency, particularly those closed work permits which don't require a great deal of education, are becoming less commonplace in Canada. As a consequence, the exception I can think of that pops or comes to mind are those jobs which are in high demand, but Canadians don't want to do, which in some cases very well could be lower skilled jobs. I'm thinking, for example, of personal support worker, which has been the subject of targeted draws in the province of Ontario, and also perhaps other healthcare-related draws which don't have as deep required education or skill set. That is a potential pathway which would require less skill than, for example, a full-blown 2-year college degree. Keep in mind that for this PSW category, oftentimes, if I recall correctly, high school is required. And in lieu of high school, perhaps this individual can take I believe it's a 6-month course for personal support work as a substitute for the lack of equivalent high school or secondary school in Canada typically required for these types of PSW or caring for high need individuals. But without knowing more about this individual besides the fact that they're on a closed work permit and have the equivalent of grade 11 or potentially high school, it's difficult to think of any other pathway for permanent residency. If we explore the pathway further for, let's say, personal support worker, the course, I believe, is 6 months in duration. And some of these have a substitute for work experience in lieu of education. I believe 1 year of work experience. So oftentimes there are ancillary requirements like, CPR, cardiopulmonary resuscitation, and first aid, and this other types of relevant education. And obviously a certain degree of English or French language skills, so that, for example, medications for a high care needs person or vulnerable person could be dealt with by this potential personal support worker or caregiver occupation. On a related note, there is a pathway for caregivers. There was one which opened in March of 2025, I believe, and closed, I think, literally within minutes because of the high demand. And on a related note, the processing times for permanent residence for caregivers is exceedingly high. I think the numbers came out very recently, and I think it's many, many months, perhaps years, before permanent residency is conferred on people in this kind of caregiver pathway. So some element of caution has to be exercised when considering a pathway for permanent residency for these kinds of lower skilled jobs. So in summary, the lower skilled jobs that may be available would be tied to labor market needs such as the one I've indicated, the PSW, which has been the subject of some draws, I believe, in the province of Ontario under the Ontario Provincial Nominee System. Some of these provincial nominee systems are connected to the Federal Express Entry program. So in order to take advantage of those, you merely have to be registered under the Federal Express Entry system. By contrast, keep in mind that there are some provinces which have their own point system, which I believe include Saskatchewan and Manitoba, amongst others, where you have to register with the province to take advantage of their pathway to permanent residency, which presumably would be tied to the labor market needs of that province, which may be particular to that province, which is sort of the rationale of why they would have their own point system. In other words, just to customize the intake of immigrants to their particular province based on their particular set of data. Yes, so typically those provincial nominee system, or PNP rather, point systems, also typically allocate a priority to proving that you will settle in one of those smaller provinces rather than simply acquire your permanent residency and then depart for a more populous province, such as Ontario, Quebec, or British Columbia. So that's another element of screening or scrutinizing people under these provincial programs for the smaller provinces, namely having their own point system, which is separate from the Federal Express Entry system. So if anybody else has joined, then they can simply pose a question in the chat for this. In terms of other questions, I see here is perhaps a related question, which is how I can help a family member overseas secure a work visa here in Canada. So for this question, the reality is, as of this year, and perhaps most of the past few months, securing a work visa here needs to show a prerequisite that you qualify under a program which would be subject to the open work permit system. In other words, those typically do not require a job offer. But outside of that, then typically there oftentimes has to be a job offer. A job offer can be those which require an LMIA, or Labor Market Impact Assessment, or the job the job offer could be under the auspices of the International Mobility Program, which includes jobs related to treaties such as the Canada-US Treaty, CUSMA, or the Chile Treaty that Canada has, or, for example, the intra-company transferee program. These programs don't require an LMIA, but merely require a job offer registered appropriately. But I should qualify that a visa officer can deny a work visa despite your possessing of a job offer if they take the view that your skills and/or education don't cohere with the requirements of the intended employer in Canada. This would be less of a situation in an intra-company transferee, where you have to show that you've worked for the outside of Canada branch before coming to the inside of Canada branch for employment for, I believe, 1 year, typically in that circumstance. So in that circumstance, there is a presumption that there is already some expertise, either as a specialized knowledge worker, working, for example, on proprietary information at the foreign branch and transferring that expertise to the Canadian branch, and to the employees in the Canadian branch to receive that expertise. Or you're a senior executive, that would be another pathway or a subcategory under the intra-company transferee program. So when we circle back to the question here, which is helping a family member overseas secure a work visa here, the circumstances then would become quite narrow. Anecdotally, it would appear that in the absence of coming out of the international mobility program, such as the ICT, intra-company transferee, it's quite likely an LMIA or labor market impact assessment would be necessary, which these days is becoming more delayed because of the increased scrutiny on LMIAs by Service Canada, also known as ESDC Canada. Canada and the requirement is not merely securing the LMIA, but also proving that once issued, the would-be worker has the requisite skills. So for anybody joining, they can pose a question in the chat. Keep in mind that the elements of this will be on social media, so if you don't want your image or voice on social media, it's probably best to simply pose the question in the chat, and I'll endeavor to answer that. So, if we look at the other questions I've seen, one says, my parents' super visa was submitted end of May 2025. I'm going to interpret this as, oh yes, there's no request for a medical exam as of yet. What should I do? Either submit upfront medical, I presume, medicals via web form, or wait for a request from IRCC. So that's sort of the whole question, essentially. So in other words, it seems there is a delay in the super visa application, and is it worthwhile to submit a medical exam now before requested? So in this case, there's a concern about the resultant delays that would occur when there is a medical requirement for a super visa. And the reality is that a medical would probably add 4 to 8 weeks after its completion for the processing, because it has to be assessed by a Canadian medical officer in Ottawa, typically, who reviews the panel physician's medical after the physical was performed by the panel physician. So the idea would be, I think, from the person who posed the question, the idea is to try to make the super visa go faster by doing the medical ahead of time. So there is some element of risk to this. The element of risk could be that the medical may not be registered quickly enough in the immigration system. On the other hand, if there is a sufficiently advanced stage of the super visa application's processing, for example, maybe biometrics were carried out or were requested, maybe a file number was already issued, so that there is, in other words, some documented movement for the application in the system by the immigration department, then the risk of the medical being done without being properly registered would be lower. The worst case would be that the medical might not be registered properly or in a timely fashion, but the likelihood of that would be lower since there is a more advanced stage of processing of the medical, or rather of the application, such as a biometrics request and fulfillment of the biometrics request, as well as the issuance of a file number. The panel physician would then be able to have that information, and that could help ensure that the medical could be sent to the proper department within IRCC Canada. And perhaps that would be a way to expedite the application by curtailing the amount of time needed to perform the medical by doing it ahead of time. Also, one thing to keep in mind is that it's good to look at the published processing times for the super visa. For example, it could vary from 30 days to perhaps 6 months, depending on the country in which the person has been lawfully admitted who is seeking the super visa. So a sort of rough starting point would be to look at the published processing time for the super visa, and then if it has exceeded that published processing time, then perhaps make a query to the immigration department. In the worst case, there could be some concern about the admissibility, such as criminal admissibility or perhaps medical, owing from the negative medical exam. It's rare because with a super visa, you have to have your own private insurance. But I know anecdotally, I've seen at least one case in a super visa application that was found to lead to some scrutiny about the medical condition of the candidate. So the premise that the question has about this presumably delayed super visa is how to make the case as fast as possible. And in the situation of admissibility, particularly criminal, or admissibility related to some other sort of enforcement aspects, such as the working for a foreign government in the past and maybe participating or being a party of some sort to things like human rights violations while you worked for the government, this could be a source of delay. There are some of the more exotic types of inadmissibilities that could lead to the requirement for third-party checks, such as for criminal or in these more exotic inadmissibilities, such as human rights violations. Third-party criminal checks may require the Canadian visa officer liaising with third-party governments or agencies to query the nature of the offense or the nature of the government affiliation in the event that the super visa candidate worked for the government of a country, for example, in a senior position. That in turn may require some element of indicating the immigration department's concerns in the form of a procedural fairness letter saying, for example, we understand that you have this government position in the past, or you had this criminal interaction, or that you worked in a senior government position, or you have this medical condition and we're concerned that this might lead to inadmissibility. And the IRCC officer would then give you a certain amount of time to respond. In light of these situations, then you have to put your best submission forward, understand the nature of the alleged inadmissibility, and get credible third-party evidence to counter the allegation. That would mean, for example, in the case of medical issues, then credible third-party medical documentation from a qualified medical specialist, as the case may be, would be useful to counter that kind of allegation, which may lead to the delay or even refusal of your application. In the case of the more exotic kinds of inadmissibilities, something showing that the criminal interaction, for example, is not equivalent to, let's say, an indictable offense under the Canadian Criminal Code or some other federal code, could be an issue. So, in other words, the response to this kind of allegation would be an exercise of equivalency of the foreign offense or charge or conviction as compared to Canadian statute. And in that case, of the more exotic kinds of inadmissibility, such as relating to being in a government position, and that government position might make you a party to systematic human rights violations. Then some country condition evidence about the nature of the person's employment in the government, as well as the activities of the government, are the relevant, or at the relevant time the person was employed in the government in a senior position, would be probed. Maybe they had no idea about the potential human rights violations committed while they were in a certain position. So those are the factors that could affect the speed of processing of a temporary application such as a super visa or visitor visa, and ways to deal with those potential inadmissibilities. So with that in mind, I will look at the other questions I've seen here. And one is, it says here, I would like to know how or about the investment visa / get permanent residency through those pathways. So when we think of investment visa, there is a kind of colloquial definition of investment visa, which is distinct from an entrepreneur. So the kind of colloquial, sort of on the street, anecdotal definition of investment visa is submitting a significant amount of money, a lump sum, to a licensed Canadian entity, and then getting a visa based on merely submitting the money to that entity. It's akin to what I think is being proposed in the United States with these gold card or gold visas, or some other gold-associated terminology. In other words, related to having passive activity and only showing the money as a pathway to permanent residency. This did exist in Canada till, I believe, 2014, until what was called the investor category, namely putting in a lump sum and then having it tied to a bank, which may invest it in certain approved investments. The simplicity of that program was simply having a lot of money. The only complexity in that program, which is now defunct, is simply the provenance of funds, or was the money you're going to put into this investor visa legitimate, based on legitimate income sources. So in other words, it was a passive way to get immigration to Canada without having to run a business. And the people who were very well off under the basis of having a successful business abroad could, again, sometimes come to Canada, immigrate, maybe come with their family. They would have the family settled in Canada, and then they would continue their already established successful business outside of Canada. And then the family is settled here. This was a concern for the immigration department because sometimes the nature of the funds, for example, would go to the province of Quebec, because Quebec had the longest running investor program. However, the investor applicant, sometimes they were from East Asia. They would deposit their money to the province of Quebec, and then they would settle in the province outside of Quebec, leading to a distortion of the intended purpose of the investor program, which was meant to settle people in the province of Quebec. Because of these reasons and others, such as the complicated nature of determining the genuineness or provenance of the funds, the programs were generally terminated in 2014. I believe in Quebec, the program was paused a few years later. So that's what comes to mind when somebody poses a question related to an investment visa to Canada. The more typical situation, at least in terms of what is surviving under the law now, are various entrepreneur programs. So these are typically entrepreneur programs administered by an individual province and assessed by the province. Each province has its own sort of selection grid for this. Most provinces have them, except, oddly enough, the most populous province, Ontario, which does not have an entrepreneur program right now. This seems to be in limbo, I believe, since February of 2024. If we exclude the absence of the Ontario one, then we can maybe look at an illustrative example like the province of British Columbia, where depending on the intended location of the business, you could, for example, locate a business in a smaller city and have a certain amount of money. I believe it's maybe 100,000, and have a net worth of 600,000, and then propose buying or establishing a business in one of these less densely populated areas in the province of British Columbia, or put in more money to the business and have it set up in a larger entity or larger city in British Columbia. The idea was that you would be showing that you had a proven track record in business. Typically, most of these provincial entrepreneur programs require proof of making money, proof of, in other words, profit making perhaps for 2 years in the past 5 years of your already established business, either as the business owner and manager, or perhaps an executive with a high degree of responsibility in a business that you have a high responsibility managing but don't own. So that would be sort of the foundation, and a rudimentary amount of English and French skills would also be required. Typically, the language test for these would-be entrepreneurs was characterized by having less of a high language requirement in terms of the IELTS test, in terms of the language for English, and the TEF in the case of assessing French language skills. But the implicit assumption in these programs, as opposed to merely having a passive investment program, is that you would be managing the business that you would either establish or purchase. And the expectation is you'd be spending about 75% of your time in Canada for the purpose of managing the business based on your expertise. So as a consequence, it's really people who are very enthusiastic about purchasing or establishing a business, perhaps a branch of their existing business. That's what people ideally are being sought for by these provincial nominee programs like Entrepreneur. At least in the case of Ontario, since there's no Entrepreneur program in place, it may be emblematic of the challenge in getting legitimate business people to use their existing business skills and capital to establish a branch or purchase a new business in Canada. So without those fundamentals, namely the amount of money mentioned and the requisite business acumen, then coming to Canada as a permanent resident through business would not be viable, because, as indicated, the sort of passive method of merely submitting a lot of money to the department through a third party is on hold for, well, we don't know. So another question relates here to an application that is taking too long, and the person said this relates to citizenship. So citizenship applications are oftentimes fluctuating in terms of the processing time. I don't recall recently, if I'm going by memory, I checked about 3 weeks ago, and I think the processing time might have been about 5 months. But as you should be aware, if you read the IRCC website, it mentions that there is a set of published processing times for various applications, including citizenship. But the published processing time given, for example, 5 months for citizenship, is based on 80% of cases in the citizenship category, which is a kind of very bureaucratic way of saying that it's the straightforward cases which take the amount of time as indicated on the published processing time contained within the IRCC website. So the question is, what if you're the 20% of cases which are perhaps complicated? And this could mean that your case could take a long time. Sometimes if you obtain the Global Case Management System notes, or GCMS notes, and you could find out perhaps that your citizenship application is characterized as what is called non-routine. A non-routine application means that there is something that is subject to more scrutiny, more necessary scrutiny by the Citizenship Department. This could relate to the admissibility because a key element of the citizenship application is submitting your police clearances. So what if, for example, there's something obvious, like you have a charge by a Canadian police officer? Then, of necessity, the citizenship application will be paused until there is a decision or disposition on your citizenship, or rather your criminal charge. So, of necessity, that means that you'd have to wait until hopefully you get a positive result on your criminal charge. A positive result could mean something like a conditional discharge. In other cases, we've seen delays for citizenship as a result of somebody's activities outside of Canada. Maybe in those cases of delayed citizenship, they present a profile of interest to the citizenship authorities, which may correspond to some kind of inadmissibility, such as a travel pattern to some countries known for stability. Think of some West Asian or Middle Eastern countries and Afghanistan and perhaps some countries in Africa. If there's a pattern of that, and if there are also corresponding absences from Canada, that's another issue as well. The amount of passport stamps showing a great deal of travel could pose two questions for a citizenship officer. Namely, do you have the requisite days inside of Canada, namely 3 years in the equivalent of a 5-year period? Or is the nature of the travel outside of Canada leading to a concern that there may be some kind of affiliation with improper elements, such as those elements related to organizations that may be committing human rights violations? And maybe there is some other third-party evidence that you may not be aware of in more dramatic situations. Maybe there is an Interpol warrant which you don't know about, and maybe that's what gets discovered, leading to delays in citizenship. I've seen clients who've find out that they've traveled, or rather they've traveled to a country on vacation. They land in that country looking forward to their vacation, and then the border or immigration officer of that country they landed in, I believe in this case it was a country in South America, they said, "Oh, you have an Interpol warrant," which is basically showing that you're being investigated for a possible crime in a country. And the person said, "I had no idea about this." And they said, "Well, yes, so you have something which is of concern for this, and that would lead to some kind of scrutiny in the context of a citizenship application, or even any other type of application, such as permanent residency of other sorts." So these are the types of concerns related to delays in citizenship. So with that in mind, there's another question here. Let me just see here, related to post-graduation work permit. So with respect to this PGWP application, it mentions there's an application the person filed, and they mentioned about this post-graduation work permit. Is it better to withdraw and reapply for this PGWP work permit when his or her study permit extension is approved as well, even though the 90-day period has passed, but it is still under the 180-day period? So this is these days are a reference to the fundamental requirements for a PGWP, namely that you should have valid study permit status in most cases, and you must apply for the PGWP within 180 days of meeting the requirements for graduation. So in a case like this, it sounds like the person's study permit status was subject to a gap in studies, and that they perhaps a gap in the validity of the study permit, and that they submitted a PGWP despite the fact that there was perhaps a gap in their study permit status. And then it looks like they reacquired their study permit status, and they want to presumably maximize the speed of the issuance of the PGWP by, for example, resubmitting the post-graduation work permit with fresh evidence that they have a valid study permit, so that perhaps to make it easier for the subsequent officer dealing with the subsequent PGWP application to approve the post-graduation work permit. I understand the strategy. Another alternative pathway might simply be to show that the study permit was approved and send a proof of the approved new study permit through the IRCC web form to the already filed PGWP application. I'm not saying that's the most appropriate course of action, because in some cases, applications to be successful have to show that you've met the requirements for the PGWP or other visa, both at the time of submitting the application and also at the time when you are ready to receive the visa or work application or study permit. By that logic, there may be some rationale to resubmit the PGWP with proof of the freshly issued study permit application and successful study permit, because in that situation, you are showing that when you're filing the PGWP at the outset, you already had valid study permit status. So it could go either way. This is the classic kind of situation where we'd want to get more details about the potential candidate for the PGWP and then compare it to the policies which are subject to a lot of discretion and are sometimes applied rigidly, and then come to a conclusion about what should be the best course of action, either submitting a new study permit or not. Okay. In terms of other questions, we see here that they're saying, it says, I'd like guidance for Canadian immigration for my sister, and she is working outside of Canada in healthcare. Okay, so for this question, the goal appears to be permanent residency in Canada. If the sister is working in healthcare, that's sort of a positive sign, but other factors come into play, such as the age of the sister, because age is a highly weighed factor under the federal express entry system. For example, age points drop quite rapidly after the age of 30. I believe the age factor peaks at age 29 under express entry. Other factors would include the nature of the work experience, whether there's licensing required, educational credential assessment for the health job. Is it a lower skilled job such as personal support worker? Or is it a physician, which requires verification of credentials? The physician category requires licensing recognition by the Medical Council of Canada, and oftentimes a job offer. Rather, in contrast, the PSW requires less training, and in some cases, training can be substituted for high school equivalent plus related work experience. So there's really too many factors to assess, and thus being unable to determine if there is a firm foundation for permanent residency. And then there's another question, which says, okay, it says, I am 58 years old, and my children are Canadian residents. I want to apply for permanent residency, and that's all it says. So in a case such as this, the facts that allow us to sort of narrow the focus a little bit include the age of the potential candidate, age 58. So right there, that particular fact means that the routine economic pathways under express entry are generally foreclosed. There's what I mentioned before, the entrepreneur programs, which are more forgiving under the factors of age and language, but those have a prerequisite of business experience. For example, a profitable or successful business being operated and managed by the candidate, usually for 2 years in the previous 5 years, and sufficient amount of funds, which could vary from a net worth of at least 600,000 to perhaps, I believe, 1.2 million. The person also mentioned, however, that the children are Canadian residents. I'll presume the person meant that the children are Canadian permanent residents. The issue there is that if they are permanent residents, There ordinarily is a sponsorship pathway for sponsoring your parents, but this has been defunct, especially, I believe, since 2020, except for those people who had submitted an expression of interest prior to 2020. The people who have not submitted an application in that program are not in the pool of potential sponsors, which last opened in 2020. So they would not be able to sponsor their parents. And as a consequence for those people, then there is no ability to sponsor a parent. I believe now the backlog of parents to be sponsored is somewhere around 13,000 applicants/parents. So they're chipping away every year at that backlog by inviting people from that 2020 pool of sponsors seeking to sponsor their parents. It's usually, I think, the spring and the fall of each year that they invite people who have submitted an application to, or rather an expression of interest to sponsor their parents every year since around 2022. So they've selected a number of potential sponsors every year. So the likelihood of opening the sponsorship program again for parents would only be if the backlog of people who submitted their expression of interest back in 2020 would eventually have their applications decided by the Immigration Department over the next few years before they open it up again to new sets of potential sponsors of parents. So in this case, the sponsorship pathway is generally out. There is, for the sake of completeness, the possibility of a humanitarian and compassionate application for parents in Canada. But these generally have to be framed with some pretty extraordinary circumstances related to, amongst other things, economic establishment and serious hardship for the parents in their home country if they were to return to their home country. So again, that's a very fact-specific kind of pathway, humanitarian and compassionate, also known as H and C. So that would determine, or rather necessitate, a consultation to determine whether this highly subjective criteria of humanitarian and compassionate could be the legal basis to settle in Canada. In terms of other more objective pathways, such as parental sponsorship, or express entry or entrepreneur categories for people around the age of 58, as I said, they seem to be quite narrow and difficult. There's another sort of question here, which is, let me see here. That is, if we see, it says, how do I apply for an open work permit? Okay. It says, I have one now that is about to expire. Okay, so in this situation, the person's asking how to extend or file for an open work permit. Typically, an open work permit is associated with successfully getting a PGWP or post-graduation work permit, or a spousal open work permit, which in turn is associated with being married or in a common law relationship to somebody who already has a work permit, typically at a certain skill level. And now post-2024, they must have a certain language level. So extending an open work permit typically under these types of categories, such as PGWP or spousal open work permit, the pathways for, let's say, spousal open work permit may not be terribly difficult because the renewal of that work permit is tied to the status of your spouse or common law partner. So if your spouse is still working and you meet the revised criteria, revised in 2025, which may include a language test, then you could continue to extend the work permit subject to the spouse's study permit or work permit status. On the other hand, if the person who posed this question is talking about extending a PGWP, then extending that as an open work permit is subject to many, many restrictions. In the ideal course of events, the PGWPs typically, not always, but typically, depending on the course of study, are 3 years in duration for the work permit. and that at least prior to 2022, it was something of a pathway to permanent residency because the occupation list for express entry was quite a bit more open and forgiving pre-2022. And merely possessing 1 or 2 years of skilled experience in the National Occupational Classification level of 0, 1, or 2, or 3 would be enough with a suitable language test score. But post-2022, with the onslaught of targeted draws for permanent residency, namely targeted draws targeting specific occupations, the likelihood of success and clarity of the path for permanent residency based on merely possessing Canadian work experience required something more specific work experience tailored to the Canadian labor market. So this meant the aggregate of people with work experience after 2022 had lesser and lesser a chance of permanent residency. So in the ordinary course of events prior to 2022, you would be able to file for permanent residency by having the express entry profile, registering the 1 or 2 years of Canadian work experience under PGWP, and thereafter filing the express entry profile and typically getting selected for permanent residency. What would happen then is you would be invited to apply and submit the EAPR, or the electronic application for permanent residence. And once that was logged in your portal, there would be a certificate of a completeness check. And the completeness check ideally would be issued before your PGWP expired. And then you would use that completeness check to get a bridging open work permit based on continued status. And your PGWP would effectively be extended. And the best case scenario is you would get permanent residency perhaps 6 months later. 6 months, I think, is the norm for invitations to apply types of permanent residency. However, in the current state of affairs, people get the 1 or 2 years of work experience under the PGWP. And even if it's of a sufficiently high skill under tier, the tier is like TEER, that level is 0, 1, 2, or 3, then they would have an express entry profile. The express entry profile is valid, but they still don't get selected for permanent residency owing to the immigration climate that we have now, where there is a decreasing amount of allocated spots for permanent residency that are decreasing even more for 2026 and 2027. The Immigration Department is going to reduce the number of permanent resident spots by 20,000 each year. So in those situations, the bridging open work permit is, unless you fall under one of those situations I've described, the extension of the open work permit is more difficult. And you may have to contemplate alternative pathways to acquire permanent residency. In some cases, just to keep your immigration status uncomplicated, it's best to leave Canada, acquire foreign work experience, and then the foreign work experience, 1 or 2 or 3 years, could be used to resubmit an express entry profile. And you could be more competitive as long as after the 1 or 2 or 3 years of work outside of Canada, you were still under the age of, let's say, for example, age 30 or so. In other words, it's a longer term pathway for permanent residency, and it may coincide with the increase in the immigration numbers that Canada's government may want to resume after the reduction in 2026 and 2027. So, okay, I just want to see if there's another question here. Okay, this question is related to a United States citizen. In terms of the background, they've submitted to us, they said they've indicated they are a US citizen and they have a husband who is a Mexican citizen / US green card holder and want to determine if there is a pathway to move to Canada. This US citizen person says that they are an elementary school teacher, and the Mexican citizen / US green card holder is a general manager of a restaurant, and they want to know if express entry is the first step. So for this, oftentimes, but not always, express entry is viable, subject to, for example, things like age, which makes it a lot more difficult. The advantage, though, for a US citizen possessing certain skills is that they could take advantage of the free trade agreement between Canada, the US, and Mexico. CUSMA, I believe it's called. The acronym keeps changing, it seems. That treaty agreement has an occupation list, which means that US citizens who have relevant work experience and applicable licensing for an occupation on that list within the free trade agreement could get a work permit in Canada as long as they have a job offer. And that could be the sort of initial foray to getting immigration to Canada, because that work permit can allow them to acquire Canadian work experience, and then their spouse can accompany them, and they could potentially both work in Canada, depending on the skill set of the main person coming under the US-Canada Free Trade Agreement. That in turn could lead to 1 year of work experience, which is relevant under CEC, Canada Experience Class. And the person said that he or she was a teacher. Teacher, fortunately, is subject to targeted draws under the current express entry regime, at least as of now, September 2025. So there is a pathway which could mean that, as such, a targeted draw means that a lower point threshold may be allowed in order to get selected for invitation to apply for permanent residency. So instead of the typical 535 points or so, if they target teachers, then the required points under express entry could be lower. I don't know the person's age in this question, but let's say they are under, 34 years of age, and then with the relevant experience in the past outside of Canada, perhaps 3 years of teaching outside of Canada, and combine that potentially with 1 year working in Canada as a teacher, they might very well be competitive under express entry. I'd also add that, I guess it's obvious for people who've researched this, that you should have a high degree of English or French language ability in order to be competitive under the current express entry system. Even with the targeted draws, the disproportionate weight given to language is high in terms of what is characterized as important under the express entry selection grid. So there could be some hope for that candidate. And then there's another question here related to delay. It says, my visa application is taking too long a time. So for this, it didn't really specify the type of application. But for example, when we look at, well, I'll just speculate that it's the person's study permit application based on the country they're sending the question from. And that is characterized by delays sometimes in processing of study permits. This could be attributed to documents that are submitted which don't appear to cohere with the standard format in the sort of collective criteria or the collective mind of the Canadian immigration officer. This leads sometimes to scrutiny of documents supporting a study permit application. These are typically third-party documents such as proof of finances and proof of savings, this kind of thing. So in these kinds of scenarios, the immigration office might contact the issuer of the document, be it a bank, or maybe if it's a corporate registration document supporting proof of funds, they might contact the corporate registration office in the country. The corporate registration department, government office in the country would be the point for the Canadian officer to determine whether the bank issued the document or the corporate registration number is properly registered with the corporate registration authorities in that country. And that may take time. So what could be the reason for the delay? Hopefully, if those checks of third-party documents, such as corporate or bank documents, are carried out quickly, then there should be no problem for the issuance of the study permit. Let me see, in terms of other questions here, we have, yes, okay. There's another question related to what are the options to get a work permit as this person has a tourist visa to Canada and possesses a Pakistani passport. So in this particular instance, the idea is to get a work permit, and there already is a visitor visa. So practically speaking, as of now, 2025, this is a long way past the COVID period of time, which was characterized by being able to file for a work permit inside of Canada, owing to the inability of people to travel. Now, as of September 2025, we're pretty well back to the norm where you cannot really file for a work permit initially inside of Canada, subject to certain exceptions, such as a spousal open work permit or PGWP. In other words, the norm is to file for a work permit outside of Canada. And that would go to a Canadian visa officer abroad. That would require, in turn, typically proof of a labor market impact assessment or proof that you come under the International Mobility Program. And as such, maybe there is, if you're from a country with a treaty like Chile or the United States, or maybe you have employment in a branch in your home country and they have a branch in Canada. However, in the situation of a Pakistani passport holder, there's no real treaties with the country of Canada related to worker mobility. So this individual worked for a company, or unless, of course, this individual worked for a company that is in Pakistan and has a branch of that company here in Canada. And perhaps the intra-company transferee or ICT pathway might be viable for that person. Let me see other questions here. The other question is, it says here, need to discuss about humanitarian compassionate considerations. Okay, so if we talk about humanitarian and compassionate considerations, presumably as a pathway to permanent residency, then in some senses, the sort of fundamental pillars of that application are economic establishment and the inability to apply under the other typical pathways for permanent residency. The other typical pathways are family class, such as parental or sponsorship, or economic categories, such as express entry or provincial nominee programs. So the combination of all that means that you have to show that you will be economically established in the context of an H and C application, which in some senses is merely showing that you have to demonstrate that you would not be a burden on the social assistance or welfare system of Canada. That's one aspect. The other one is that despite the fact that you don't qualify under other categories, such as the skilled worker or express entry, that you want to articulate that you should still be able to acquire permanent residency because the nature of the difficulties you have justify this. And this typically relates to circumstances that would induce a reasonable officer dealing with the H and C application to want to grant that kind of relief, namely permanent residency on these very discretionary grounds. So the factors that would go into these types of humanitarian and compassionate applications would be very individualized to the circumstances of the person seeking the H and C application. What I mean by individualized is, for example, where is the person's ordinary country of citizenship or country of residence? Are they subject to hardship there because of perhaps some economic catastrophe that is going on there? Or maybe there's political instability that is really profound in that country of origin. Maybe that political instability affects them in particular. Maybe because they're a member of a party, politically speaking, opposite to the political party in power. Or maybe they're a member of a minority, which means that they are in a situation where they cannot avail themselves of protection. We could sort of see the sort of kernel or basis or development of this with programs related to the instability and the granting of work permits to people from Ukraine or Iran, where there is a significant amount of political instability. this ties into the other foundation for humanitarian and compassionate, which is ideal from the point of view of the immigration department / officer dealing with the H and C case, namely that these people are ideally inside of Canada and cannot really return to their home country because of the ongoing political instability. So this would be a circumstance ripe for a potential humanitarian and compassionate basis for PR, because both Ukrainians and Iranians were able to file for work permits who are in Canada and thus have entered Canada legally and have worked in Canada legally, and maybe the instability in those countries is persisting as it is in Ukraine and arguably in Iran as well. And that would perhaps be a good foundation for a humanitarian and compassionate application, particularly if the economic establishment for these candidates is borne out. That economic establishment would be proven with the foundation of a valid work permit, which would be the case in these hypotheticals that we're discussing, such as Iranians and Ukrainians who have work permits oftentimes, and they could demonstrate their economic establishment by working in Canada. That's an ideal situation leading to permanent residency. Now, this is not the norm. There are other categories where people sometimes have to come to Canada perhaps on a visitor visa, but simply never left after renewing their visitor visa maybe once, and then simply going underground, working illegally. Maybe these people have acquired some savings. This would be a bit more problematic because the immigration manual oftentimes has this reference to the inability to leave Canada being beyond the person's control. This is distinct from a person who simply came to Canada as a visitor and never left, just started working. Anecdotally, we've come across this situation sometimes in extraordinary circumstances where the person came as a visitor and never left Canada and ended up working for 10 or 15 years, maybe having a family. In one case, I recall, the person somehow got a real estate license and made a lot of money. It's an incredible kind of story, and that person did not leave. That humanitarian case was successful because they had a child in Canada, born in Canada. That child had a healthcare condition which could not be treated well in the country where that person came from. So even though the person acquired work and worked illegally, their combination of economic establishment plus the nature of the hardship that would befall their Canadian-born child led the humanitarian and compassionate officer to acquire a sufficient amount of sympathy to use their discretion to grant the permanent residency on humanitarian and compassionate grounds. An example of what could be a positive H and C application for this in terms of other questions here. I just want to see, there's another question. Okay. It says here, the question is, I am a software engineer, 40-something years old, residing in the United Arab Emirates since 2009. And it says here, currently working for an enterprise resource planning entity. So that's a highly data-driven and analytical occupation. The question appears to be, what are my chances for immigration? So the labor market in Canada has shifted a lot since 2022. And this is very tangible in the case of software engineers, where you could, during COVID, get hired very easily for those companies, the big ones, Facebook, Amazon, Apple, Alphabet, those types of companies. However, the labor market was less favorable for people with software and related skills after 2022. And this was selected, or rather, this was reflected, rather, in the selection grid for Canadian immigration, where there was a general acceptance of people with these types of skills prior to the year 2022 of these highly skilled applicants. But now with the occurrence of targeted draws, typically related to healthcare and maybe teaching, and a few other jobs, the chance of success for a approximately 40-year-old with specialized software engineering is not as high right now. Unless, of course, their skills are so much in demand that they could get a job offer. Maybe they see something in the Canadian job bank, which is something worthwhile to look at if you have highly prized or in-demand skills. That is at www, I believe, jobbank.gc.ca. Maybe you could actually get recruited by an employer based on your particular software skills, which may be in short supply in Canada. That could form the basis for a work permit and then Canadian work experience. And maybe if they restore the points under express entry for the kind of bonus where you get 50 extra points for having a job offer, maybe 200 if it's an executive job offer, that could in turn reinforce the pathway for permanent residency under express entry based on a job offer. But in the current climate, it's a bit speculative as of now, September 2025, where there could be a firm pathway outside of a job offer for a highly skilled software engineer residing in the United Arab Emirates. Unfortunately, because of the sensitivity related to the absence of demand for software engineers, as opposed to pre-2022. So in terms of other questions here, it says, it says we are on a super visa and both of my children are settled in Canada. Both me and my husband are old with no source of income back home. Can we apply for permanent residency now? So this question is highly connected to the fact that super visa candidates can stay for, let's say, the medium term, for about 5 years. This is kind of paradoxical because a super visa is a temporary visa, yet you could reside for 5 years in Canada. 5 years, by most people's definition, is not temporary. This leads to a loss of connection or establishment or any kind of establishment for the parents in their home country who came to came under super visa status for 5 years. Just bear with me for a second here. Okay, so if we go back to the question here. Oh yes, so 5 years. So if we look at the landscape now, this means no doubt there will be a significant amount of people, parents of Canadian permanent residents, for example, who are on super visas, who have children in Canada, who have the support of their children who, for example, supported them in their super visa application. So the idea is that the parents are more comfortable in Canada and want to convert their super visa status to permanent resident status. This may no doubt lead to an influx of these parental-based super visa candidates wanting to convert to permanent residency. Technically speaking, the pathways are few. I've talked about H and C, or humanitarian and compassionate, but the humanitarian and compassionate pathway does require those two pillars of economic establishment in Canada, and also the issue of some significant difficulty in their home country if they were to go back to their home country. Enough difficulty to elicit sympathy on the part of the immigration officer tasked with dealing with the humanitarian and compassionate application. Without expressing some kind of difficulties in the home country, such as, for example, being a minority in that country or being a target of crime, a disproportionately high target of crime. I don't want to say persecution because that's a refugee situation, but let's say targeted based on the basis of being perceived to be wealthy, for example, or their ethnicity, or some other characteristic that is identifiable, or unless they are subject to some other unique circumstance. Let's say they have a complete, utter lack of social support network in their home country because their relatives are no longer in the home country, and they are vulnerable in some aspect. And at the same time, the children who supported them on the super visa application have an excellent financial support system in Canada. Let's say the children in Canada have good jobs, which means they can support their parents. Then those circumstances arguably might be the basis for a humanitarian and compassionate application. But again, that's something that would be more meritorious to assess in the context of a comprehensive legal consultation. You could do that with us at some point. That would be the way to go about considering transitioning from super visa to humanitarian and compassionate landing for permanent residency. So let's see, with that in mind, those are the questions I saw here today. It's a privilege to allow me to give you some insight and general guidance about Canadian immigration law through these periodic webinars, which are formed based on the questions that I receive during the chat. These webinars are usually the third Saturday of the month, and here at Chaudhary Law Office, we want to at least disseminate some guidance in a general sense so that people can filter through the kinds of rumors that are perpetuated on social media. These rumors are pretty egregious and inaccurate in the non-English or French social media platforms. So it's hoped that this can provide some guidance that can clear the misinformation that is out there on the internet, where we here at Chaudhary Law Office endeavor to provide full service immigration in applications to immigrate to Canada or other related tasks such as citizenship or addressing refusals to Canada, refusals to enter Canada, or refusals of visas to Canada. And if you're subject to inadmissibilities, such as the loss of status, we also deal with those. So feel free to reach out to us here for your Canadian immigration needs. And thank you.